So, good morning, friends. I welcome you to Advocate Ajay Kumar Supreme Law International YouTube channel. So, how are you doing in this lockdown time? Yeah, it's tough, but then we have to bear it. I keep on talking to you on one of the topical earning law issue directly affecting your day-to-day life. In my previous broadcast, I have talked to you about the ban of liquor and the power of government to do so. I told you very clearly and in a very candid manner that there's no law under which the government can ban the sale of the liquor, especially the government of India, which was done. I referred this conclusion based on two laws. One, it's a state subject, so center can't force the state to ban the sale of the liquor, and that's why it is the call of the state to decide whether they want to continue with the sale or they do not want to continue with the sale. But even if we take into the account the National Disaster Management Act, currently which is imposed throughout the country, so even a close look at that act and looking at the various sections and power under that act, the ban could not be imposed because, as per the Food Standard Safety Act of 2006, liquor is part of the foodstuff grocery item. And even under this act, the essentials item, essential services, foods and groceries were allowed. So how you can allow certain things on the list and on the other you will ban certain things. So that was my second argument. Ultimately you saw that my stand got vindicated and now liquor is open for sale in almost all the states, be it Maharashtra, be it Delhi, be it Kerala, be it Punjab, Haryana. So it was basically left to the states to take a call, and they have allowed the sale of the liquor. Not only that, now they have made arrangements to get it home delivered too. So that was the stand one. The other burning topic on which I talked to you was the issue of salary to the employees. The government came out with a very hard-hitting advisory asking the private employers to pay, not to pay only, but to pay in full. Not it stopped there, but it said to pay on time, and if not, any violation in doing all three would lead to punishment, punitive action, jails. I outrightly said that government has no power to issue such kind of dictatorial advisories or mandates. The advisory was illegal, unconstitutional, and highly arbitrary. And you see ultimately what happened. The Supreme Court has to intervene through API. And when government was asked to file its reply, the government decided better to withdraw the advisory because they knew they stand on a very weak foot when it comes to law. So that was the second issue I talked to you. I hope it is settled. In case you have any issues, you can always get in touch with me. Talk to me. I'm available through my website, www.ajaykumar.com. You can call me even on my number, 9818-320-572. I repeat, you can call me on my number, 9818-320-572. Anyhow, but the today topic on which I'm going to talk to you is again very burning, is affecting each and every one of us, and that is the issue of the rental for almost the 60 days of lockdown, when you were not allowed to step in your office, your premises, and now you are being asked to pay. I know it's tough. At one hand, you have no revenue stream, and the other hand, you are being forced by the landlord to pay. I understand advocates like me, chartered accountants, and various other professionals, because of this lockdown, they are not earning. But at the same time, the salary for the staff, the supporter staff, and now this burden of 2 months rental is huge. So let's today decode what the law says about this lockdown rental. To make my point clear, that will you pay the salary when such a unforeseen circumstances has taken place? Nothing is beyond your control or rather in the control of anybody. So can this in legal term be part of doctrine of frustration? What is section 56 of Indian Contract Act? That is the issue. Because if it is allowed to be dealt with, doctrine of frustration means it's totally impossible for anybody to perform the task. Then of course, there would be no question of paying the rent. But the legal question or the moot point here is, can it be part of it? Let me quote a recent judgment of Delhi High Court, where the Justice Pratibha H. Singh has clearly said in a case that Section 56 of Indian Contract Act can't be part of a lease agreement. Citing a decision of Supreme Court and a decision of double bench of Delhi High Court, that is in the case of Leela Hotels Private Limited and Airports Authority of India Limited, she said that any agreement is a executed agreement, and Section 56 is meant to be applied for anything which is to be executed. So when the conveyance is completed, when the deed is completed, Section 56 won't apply to it. And to support her judgment, she has quoted various other precedents and judgments. Now let's assume a situation, number two, that your lawyer was smart enough and he has been able to insert a clause like force majeure and this doctrine of frustration, imagining something very unnatural or close to COVID-19 like situation in your agreement. Then can you claim relaxation? Can you not pay the rent? That was the another issue which the court has examined. Now again here the justice, quoting various judgments, says no. If that is the case, where it is part of the agreement between landlord and the tenant, then the Section 32 of Indian Contract Act would be applicable, but not Section 56. Now let's see what Section 32 says. Section 32 is again very clear. It says if this very clause is part of the agreement, then to receive benefit under this clause, the tenant will have to vacate the premises, so that the contract became void. If you are not vacating the premises, you want to continue enjoying the premises, then you are bound to pay the rentals because it will be treated as agreement being there. Nothing has happened to the contract between two parties. So it was again ruled out that even if it is part of your contract agreement, you can't ask for benefit under this. What was the case? It is interesting. Here, an shop owner who is occupying a shop in Khan Market, very posh locality of Delhi, one of the highest rentals in Asia, not in India. So this very gentleman approached the court recently and asked for a waiver of the rent, citing the COVID lockdown situation. The rental here is 3.50 lakhs per month. It's a different story that this very shop is being occupied by this very tenant since 1975 for a mere sum of rupees 350. However, in 2017, by an order of court, the rent was enhanced to 3,50,000. Now this tenant is again at the door of the Delhi High Court asking for the waiver. And here there is no agreement now between the landlord and the tenant. So the court observed that in case if there is no such agreement, then the matter would be examined under the Tenancy Act, under the Indian Property Transfer Act. And going by these two acts, again, it is very clear by various judgments given by different high courts and Supreme Court that temporary non-use of the premises doesn't affect the right of the tenant. He is in the possession of the premises. Not being able to use it for certain reasons, for some period, would not give him the benefit of not paying the rental to the landlord. It is very stabilized case law as far as the Indian legal system is concerned. So on all these three counts, it has been ruled out that a tenant will enjoy any kind of discount, any kind of relaxation, or complete waiver of rental for these 2 months. Now, the last position on which the matter was argued was what about the protection given by an advisory by Ministry of Home Affairs. The court commented on that also and said, yes, there is a protection given by Ministry of Home Affairs, but it is not meant for cases like this. It is meant for migrant workers, students, standard tourists, or any other such hapless person who is unable to move out of the premises on account of lockdown. So a commercial enterprise or a professional will not enjoy any protection under this very advisory. So the last question is, or which would be coming to your mind, can there be any relief? If not at all in any of these professions, yes. The court came there and said the maximum could be done is that the payment will have to be made in staggered manner, in installment. You can delay the rentals, but outright not paying the rental is not the option. I hope you have liked my video. You have liked my live telecast on this very important topic. Do give me your thumbs up and subscribe to my YouTube channel, Advocate Ajay Kumar, Supreme Law International, for such kind of updates, both live and also through my videos, uploaded videos on YouTube. If you have any question, you are most welcome to reach out to me through email, through my phone number, through my website, through YouTube chat, through Facebook chat, or Messenger. I repeat my number 9818320572. I repeat my number 9818320572. If you have any question, I can see some of the visitors here. If they have any questions, you please type in my chat box. I will try to answer your question. I'm not seeing any questions coming from you. I understand it's too late in the night. We would meet again very soon on a very pertinent and a burning topic. Thank you. See you again in another video with another topic. Advocate Ajay Kumar, Supreme Law International. Thank you. Thank you very much.